I first realized something was wrong on a windy Thursday morning when I found a bright orange notice stapled to the gate of my old timber frame barn. The paper flapped like it was trying to escape. But the message was impossible to miss. Violation of HOA building restrictions, immediate compliance required. I didn't live in an HOA. My nearest neighbor was half a mile north. And beyond the tree line sat the sprawling, uniform neighborhood of Sycamore Estates, identical beige homes. Identical mailboxes, identical yards. I had nothing to do with them. Or so I thought. The notice accused me of constructing a non-approved structure visible from HOA property, which I found amusing, considering the barn had been standing since 1912, long before any HOA existed. Long before most of the town even existed. I figured it was a clerical mistake. Maybe some overzealous board member asserting dominance. So I crumpled the paper and tossed it in the truck. 2 days later, a second notice arrived, this time certified mail. Then an email. Then a phone call. The HOA president introduced herself as Barbara Wexley. Speaking with the same tone you hear from someone who wants you to know she's important. She informed me that the barn violated community sightline ordinances and demanded I either paint it to match their color scheme or remove it entirely. I laughed, which she did not appreciate. "Ma'am," I said, "I'm not in your HOA. You have no authority over me. My barn is on my land." There was a small, tense silence on the line. "That is a matter of dispute," she replied. The next week, I received a lawsuit. The HOA was suing me. The claim? That the barn, and approximately 4 acres of their neighborhood, was technically under their domain due to a 25-year-old plat map they believed gave them oversight. I didn't want to fight. But I wasn't about to let a committee of lawnmower tyrants dictate what happened on land my grandfather had worked. So I hired a boundary attorney, who began digging into county records. That's when things got strange. The original land deeds told a different story, one that none of us expected. It wasn't the HOA that had the claim. It was me. Not just to the barn. Not just to the 4 acres they mentioned. But, according to a survey recorded in 1937 and never legally overturned, to all 46 acres that Sycamore Estates now occupied. My attorney looked up from the documents with a stunned expression. "Technically," he said, "the entire neighborhood is sitting on your land." And that was the moment everything changed. The more my attorney, Martin, uncovered, the stranger the story became. The original land deeds showed that my great-grandfather, Samuel Carter, purchased the entire 50-acre tract in 1908. The barn stood near the center. And the rest was forest until the late 90s when development began. Here's the twist: the development company that built Sycamore Estates filed a boundary adjustment request in 1997. But the county board rejected it due to missing documentation. The developers built anyway, illegally relying on a preliminary, non-binding survey rather than a finalized plat. The HOA had no idea. They assumed everything was officially approved and recorded. It wasn't. So as far as the law was concerned, every single house, every fence, yard, streetlight, and mailbox sat squarely on my family's land. When Martin explained this, I couldn't decide whether to laugh or panic. "What does this mean?" I asked. "It means the HOA has accidentally picked a fight with the one person who can legally evict all of them," he replied. I didn't want that. I wasn't some cartoon villain looking to throw people out of their homes. I simply wanted to be left alone and keep my barn standing where it had always stood. But things escalated when the HOA refused to drop the lawsuit, insisting I was fabricating a desperate counterclaim. Barbara called again. Her tone clipped and icy. "This is your final warning," she said. "Remove the barn or we'll pursue full penalties." I took a slow breath. "Barbara, I'm trying to handle this peacefully. Your neighborhood is on my land. not the other way around. That's absurd, she snapped. Your attorney is misleading you. We have our own legal team. Then tell them to check the county deeds from 1937, I said. They'll find the truth. She hung up without another word. 2 days later, the HOA's law firm requested a temporary restraining order preventing me from modifying disputed property, my own land. That was the final straw for Martin. He filed a countersuit, demanding the court formally recognize my ownership and seeking damages for harassment. Word spread quickly. Sycamore Estates was in an uproar. Homeowners demanded answers from their HOA, who provided none. Rumors surged across local forums. Is our neighborhood illegal? Could we be forced to move? Did the HOA screw up? Meanwhile, the court scheduled a hearing, one that would determine whether my barn stayed, whether the HOA had authority, and whether an entire neighborhood had been built on stolen soil. The past was coming back, and it wasn't done with any of us yet. The courthouse was packed the morning the case began. Homeowners from Sycamore Estates filled every bench, whispering anxiously. HOA board members filed in wearing matching navy blazers, as if uniforms could save them. Barbara sat stiffly at the front, flipping through a thick binder labeled infractions and violations. She didn't look at me. Judge Halpern opened the session with a weary sigh. The kind that said he'd rather be anywhere else. Let's proceed, he said. The HOA's attorney went first, arguing that the barn violated community aesthetics and insisting their plat map showed they had jurisdiction over my property. He confidently presented the documents. Until Martin stood, calm as the barn's weathered oak beams. Your Honor, Martin said, these documents are not certified. They were never approved by the county. What was approved is in the following record. He placed a heavy stack of old deeds, stamped and sealed from 1908, 1937, and 1974. Judge Halpern flipped through them, brow furrowing deeper with every page. Next came the bombshell. Martin called County Surveyor Evelyn Brooks to the stand. She explained the rejected 1997 request, the improper development, and the fact that no legal transfer of land had ever occurred. The courtroom fell silent. So you're saying, the judge asked slowly, that Sycamore Estates was built entirely on land belonging to the Carter family? Brooks nodded. Yes, Your Honor. Legally, it was never subdivided or sold. A wave of shocked murmurs swept through the room. One homeowner gasped loud enough for everyone to hear. Barbara stood abruptly. This is nonsense, she barked. We have maintained and governed this neighborhood for 25 years. With respect, the judge replied. You can maintain a house sitting on another man's lawn. Doesn't make it yours. Martin then submitted our countersuit, recognition of ownership, removal of the HOA's claims, and damages for harassment. The HOA's attorney tried salvaging what he could, but it was like trying to bail water from a sinking ship with a teacup. When closing arguments ended, the judge recessed for an hour. I stepped outside, breathing in crisp air while homeowners approached me nervously. Some apologized for the HOA. Some begged me not to evict them. Some were furious, though not at me, at the people who had lied to them. When the judge returned, everyone fell silent. He read the ruling clearly, each word landing like a hammer. The court recognizes the Carter family as the lawful owners of the land on which Sycamore Estates resides. The HOA's lawsuit is dismissed with prejudice. Further, the HOA is found liable for harassment and damages. Barbara slumped into her chair. But the judge wasn't finished. Furthermore, he continued, as the landowner, Mr. Carter may choose to negotiate new terms for land use or pursue other remedies. Gasps echoed. The earthquake had begun. Winning the case didn't feel triumphant, not at first. Homeowners were terrified. Some were angry. Some were grateful. But all of them waited to see what I'd do next. Technically, I could have evicted the entire neighborhood. Legally, I could have charged massive rent for land use. Realistically, I didn't want to bulldoze homes or ruin lives. I simply wanted peace and an end to the HOA's harassment. But the HOA board, they doubled down on arrogance, refusing to resign and insisting they would appeal to a higher authority. Their bluster died quickly when Martin reminded them that appealing would only drag more attention to their illegal governance and expose them to further liability. The homeowners held an emergency meeting without the board. They voted, unanimously, to dissolve the HOA and negotiate directly with me. Barbara and the board were removed on the spot. The next evening, I met with a group of representatives in the community park, a park that technically belonged to me. They brought folding chairs and uneasy smiles. One homeowner, a middle-aged teacher named Robert, spoke first. "We want to make this right," he said. "We didn't know. None of us knew." "I understand," I replied. "I'm not here to punish anyone." "So, what now?" another asked. I told them my plan. First, they could stay. Second, they could purchase the lots from me at a fair below market price, essentially what the land should have cost in 1997. Adjusted modestly. Third, those who couldn't afford it could sign a ground lease agreement at a token rate that covered taxes and maintenance. Fourth, the HOA would never return. The community could self-govern voluntarily. Silence settled over the group, relief, disbelief, gratitude. "That's incredibly generous," Robert said quietly. "It's fair," I replied. "I want my barn left alone. Beyond that, I want neighbors, not enemies." News of the arrangement spread quickly. Most homeowners accepted immediately. Within 3 months, the land sales were finalized. The ground leases signed. And Sycamore Estates legally, finally, put in proper order. The barn still stands. Its weathered boards catching the morning sun just as they have for over a century. Sometimes I see kids from the neighborhood walking the trail near it, waving as they pass. As for Barbara, she moved away quietly, leaving behind a reputation more infamous than any HOA newsletter she ever wrote. People still talk about what happened. Not because an HOA sued me, but because they accidentally sued the one man who owned everything under their feet and lived to see the day he chose. Cooperation over chaos. And that, in the end, changed the neighborhood forever.